Key highlights of Insolvency and Bankruptcy Code, 2016. By corporate professionals. Objective behind the code. This code seeks to consolidate and amend laws relating to reorganization/revival and insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner. The code seeks to amend the following 11 laws. Indian Partnership Act, 1932. Central Excise Act, 1944. Income Tax Act, 1961. Customs Act, 1962. Recovery of Debts Due to Banks and Financial Institutions Act, 1993. Finance Act 1994. Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, 2002. SIC Industrial Companies, Special Provisions, Repeal Act, 2003. Payment and Settlement System Act, 2007. Limited Liability Partnership Act, 2008. Companies Act, 2013. Application regarding insolvency of the company or an LLP will be filed before the National Company Law Tribunal, NCLT, and before the Debt Recovery Tribunal, DRT, in case of individuals or partnership firms. NCLT and DRT will be called as Adjudicating Authority. Now, the question is who may invoke for the insolvency resolution process. The insolvency resolution process will be initiated by financial creditor and operational creditor. Financial creditor means whose relationship with the entity is a pure financial contract, such as loan or a debt, and operational creditors are those whose liability from the entity comes from a transaction on operations like trade creditors, employees, utilities. Further, the company itself may invoke the insolvency resolution process. An insolvency resolution process will be completed within 180 days from the date of admission of application by the adjudicating authority. Thereafter, the adjudicating authority will announce moratorium period, then appoint a resolution professional, and all the powers of the board get suspended and vest with the resolution professional. Resolution professional will constitute a committee of creditors, which consists only financial creditors. These 180 days may be further extended by 90 days after the approval of adjudicating authority. Timeline. In case of fast track mode, insolvency process will be completed within 90 days plus 45 days extension. Moratorium order by adjudicating authority equals cooling period. Institution of suits or continuation of pending suits or execution of any judgment, decree or order in any court of law. Transferring any of its assets. Proceeding or action under Safareezy Act, 2002. Resolution professional. Manage the affairs of the corporate as a going concern. Collect all information relating to assets, finances and operations to determine financial position. Receive and collate all the claims. Take control and custody of any assets, whether in India or outside India, other than the assets of Indian or foreign subsidiary. Enter into contract for and on behalf of the company or amend any existing contracts, etc. To raise interim finance. Committee of creditors. Consist of only financial creditors. First meeting to be held within 3 days. All the decisions will be decided by 75% of the financial creditors in value. Prior approval is required for raising of funds, creation of security on any assets, change of capital structure in any manner, change of any ownership of the company, undertaking of any related party transaction, change in MOA or AOA, etc. Resolution plan. Approved by the Committee of Creditors and then, by insolvency resolution professional. Finally, the plan will be approved the adjudicating authority. The resolution plan will be binding on the company, its employees, members, creditors, guarantors and other stakeholders. If not approved already, within 180 days or adjudicating authority rejects, the liquidation order will be passed. New institutions. Insolvency and Bankruptcy Board of India. Registration of insolvency professional agencies, insolvency professionals and information utilities. Carry out the inspections and investigations. Vests with the powers of a civil court under Code of Civil Procedure, 1908. Insolvency professional agency. Promote the services of competent insolvency professionals. Protect the interest of debtors, creditors, etc. Membership to insolvency professionals. Minimum standard and code of conduct for its members, i.e. insolvency professionals. Information utilities. To collect, collate, authenticate and disseminate financial information to facilitate insolvency, liquidation and bankruptcy. The information utility would thus hold an array of information about all firms at all times and make available undisputed and complete information immediately. New professional will become insolvency professional. Insolvency professional, who will conduct the insolvency resolution process, take over the management of a company, assist creditors in the collection of relevant information, and manage the liquidation process. Enrolled as a member of an insolvency professional agency and registered with the Insolvency and Bankruptcy Board of India. Every insolvency professional shall abide by the Code of Conduct. Benefits. First, time-bound settlement of insolvency. The Insolvency and Bankruptcy Board of India will keep watch. Banks and asset reconstruction companies immediate gainers. Locked up assets will be freed. Second, comprehensive coverage companies, partnerships, LLP, individuals and more can be added. Faster turnaround of businesses. Database of serial defaulters. Shift from equity to debt. Third, creation of bankruptcy regulator. Protect workers. New class of insolvency professionals. Lift lender comfort. Significantly improve ease of doing business. For more information please contact Mr. Akit Sai or Mr. Meroj Kumar from Corporate Professionals.